14B District Court is now in session with the Honorable Lorraine C. Washington presiding.
Thank you. The court will call the case of the state of Michigan versus Samuel Dewalski, case number 21F00190.
APA Rachel McDuffie on behalf of the people.
Assistant Public Defender Allison Miller here on behalf of my client Samuel Dewalski. He is experiencing some nerve pain, is going to remain standing for that reason, so I'll remain standing as well. It is difficult for him to sit right now, he said.
Thank you. Can you state your name, sir?
Sam Dewalski.
Thank you. All right, we're supposed to be here for sentencing today?
Yes, Your Honor. I did have a chance to go over the report with Mr. Dewalski. No corrections, modifications. We do ask the court to follow the recommendation.
Ms. McDuffie?
I agree with the recommendation, and I first of all want to thank Mr. Dewalski for stepping up and taking responsibility for this case. My concerns are actually that I'm not sure to what extent he really understands why he's here today, what happened in this case, and what needs to happen so that he doesn't end up here on another one. We started out with him wanting to represent himself, and I was very grateful that he kind of thought better of that and with counsel. I can see in his statements, in his sentencing statement, that he's demonstrating some sort of compassion, and I appreciate that. The problem is that this is a stalking case, and usually the concern is not indifference, but it's actually the very ill-informed opposite of that, which is behavior that's basically obsessive, and he doesn't mean any harm, or believes that he doesn't, but obviously the underlying case allegations are disturbing. Mr. Dewalski does not appear to quite be in touch with reality in general here. Some of his comments are making me wonder to what extent programming is going to be able to take effect if he doesn't have a sense of even where he is right now. If he really, does he understand that he's in court right now, what we're doing? These are normally sort of competency questions that will come up, but and that his responses about his contact, his behavior, and what his restrictions might be, and he sort of gave he kind of equivocated, and as if he may or may not follow, some of those things, depending on. I just don't know what to think here. I'm glad to see the recommendation for a mental health assessment. I certainly think that one is relevant. This case is older, and the history that I have is older. I don't have updated information on anything that may have been going on with him in the past few years while this original event happened. I hope that he cooperates to the extent that he can. It's difficult. It's the tricky part about this, a situation like this. It's kind of difficult to ask somebody to cooperate with an assessment when they may not have a good sense of themselves and where they are in the world to even be able to do that. I think that he can, based on what I've seen. I just hope that he's willing to. That's all I can say.
Thank you. Is there anything else you want to say on behalf of your client? Because I have the same concerns.
Absolutely, Your Honor. And I am stepping in for Mr. Lebo. So unfortunately, I don't have quite the same background here as Mr. Lebo may have. But I think the recommendation is fitting, and I certainly hope also that the assessment will be helpful, and I think we'll learn more as he goes through probation. I hope that it will be helpful.
Thank you. Mr. Dewalski, sir. So first of all, I'm just gonna be direct because that's who I am. It says in here that you believe that you're in heaven?
Yes, me and my people get to heaven now.
You and your people get to heaven now. What does that mean?
There's something to do with the saints. The saints are not understood. Appreciate it. People that smear me and my people, say that I'm not aware of my surroundings. I'm very aware of my surroundings.
Okay. You say you're very aware of your surroundings.
I think I'm very misunderstood by the system, by everybody involved here.
You're very misunderstood by the system? In what way?
Stigma and bias against people with schizophrenia and instead of embracing schizophrenia, which I
Can you speak up just a little bit for me?
instead of embracing schizophrenia, which I think people trapped in the system should do, they treat it as like a disease when I know that it is getting to heaven now.
Oh, that's how you see schizophrenia?
Point of view, you're not going to understand that. I understand and respect your point of view, but this is like the meaning of my life to stand up for these people and myself.
I see. Okay. Let's say I accept your point of view as your truth, right? Having that understanding, though, brings me some concerns, but that's not why we're here right now. Particularly, we're here because of the stalking piece. So then I have to ask you whether you're going to follow my orders if I say no contact with her.
I will do that. I don't want to cause her any, I care about her. I don't want to cause her emotional distress.
And you understand that that's what you do when you have contact?
That's what this has been allegedly said.
And she told you personally not to contact her, right?
Yes.
So if she tells you that, then those are her emotions, her feelings. You told me you could respect my opinions, right? Can you respect her opinions
Yes.
and respect where she is and where her husband is? Because she has a husband, right? I need you to answer yes or no to that.
Yes, I'm aware of that.
Okay, and so you've been told not to contact either one of them, right?
Yes.
All right, so are you willing to follow those rules?
Yes.
Because if you violate them, you know what happens?
Yes, I'm aware.
Okay, what do you think happens?
I could go to jail.
Yes, exactly. You don't want to do that. And I don't want to have to send you there. But I need to make sure she feels safe and that she is safe. Okay? And her husband too. Are we clear on that part?
Yes, I want that as well. Yeah.
All right. Well, I'm going to follow the recommendation. It is the sentence of this court that you serve 365 days in the Washington County Jail. Credit for no days. The 365 days are suspended. What that means is, as long as you follow my orders, then you don't have to do any jail time. If you don't follow the orders, then you have to go to jail, like we just talked about. You're on probation for 60 months. That's a total of 5 years. You understand that part?
Yes.
All right. Fines and court costs in this particular case? For a total of $495. You're to meet with probation when and where directed, including any and all home visits, weekly phone reports, and probation group meetings. You're to attend and complete a mental health assessment and follow all their recommendations, including medication, if that is ordered. You're to attend and complete the batter's intervention assessment and mental health assessment and treatment if deemed appropriate. You're restricted from having any alcoholic beverages in your home. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or any treatment provider. You're to provide monthly verification of compliance with all of these conditions. To do that, you have to go online and fill out a form. It's called a probation report form. You have to do that every month, okay? Is that a yes? I have to have you answer out loud. Okay. And your attend court reviews as ordered by the court to provide proof of compliance of all of your probation conditions. You're to make earnest efforts to maintain legitimate employment. I see you're employed, so please keep that up. You're not to engage in any social media contact with the victim in this case. No assaultive or threatening behavior towards her whatsoever, no contact with her, no going to her place of residence or place of employment, no contact with her husband. No use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, no being in the presence of anyone using those, or firearm components, ammunition, or other dangerous weapons, and no being in the company of anyone carrying those or using those. I'm gonna see you here in about 30 days. That's gonna put us on September 23rd, 2024 at 10 a.m. I'll do this via Zoom. But do you use Zoom, sir, or you only do in person?
I prefer in person. I had trouble with the camera the first time.
Okay. All right. Then we'll make it 11 in person, okay? All right, we'll see you back here on September 23rd, okay, sir?
Okay.
All right, thank you.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Nicholas Jones. Mr. Jones, can you state your name, please?
Yes, Nicholas P. Jones.
Thank you. Good morning, Mr. Jones.
Good morning, Your Honor.
Mr. Jones, it appears that you are in violation of your bond. It looks like you've tested positive for THC at every single time you've tested positive. So I have to arraign you on a violation of the bond. Do you have a copy of the report, Ms. Muller?
Your Honor, I'm just pulling it up right now. I'm trying to see. I did not catch it prior to this. Let me see if I have it. I'm sorry. Your Honor, I don't believe I have it.
Check and see if you have a copy of this. So, Mr. Jones, the bond violation alleges that you tested positive for THC on June 17th, June 27th, July 3rd, July 11th, July 16th, July 25th, July 31st, August 8th, and August 16th. The magistrate set a bond condition within which you would test, and you were not allowed to have any illegal substances or marijuana of any sort, and it appears you're violating that condition of your bond. You're entitled to have a hearing on this matter, at which time, if it is shown that you did violate the terms of your bond could be revoked. It appears you don't have a medical marijuana card for this, and I don't know whether medical marijuana was a part of this charge or not.
The allegations in the case do involve THC.
All right. So, do you want to talk to your client about his options at this time, Ms. Muller?
Your Honor, yes, if I could.
Thank you. We'll put you in a breakout room. Pass this matter. Lane Township versus Nicholas Jones, 24T00166.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Nicholas Jones. Mr. Jones, please state your name again.
Nicholas P. Jones.
Thank you. All right, what would your client like to do with respect to the violation of probation?
Your Honor, for the bond violation, Mr. Jones will admit,
You're
would like to provide an explanation and ask a question just regarding what happens next, or I guess next steps.
All right, thank you. Mr. Jones, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. It's my understanding, sir, that you're going to waive your right to have a hearing on the bond violation and that you're going to admit to it. Is that correct?
That is correct.
All right. Sir, is it true that you tested positive for THC at every time you've tested with all the dates that I listed earlier?
That is correct.
All right. Thank you. I find that there's a knowing and willing admission to the bond violation. Are you satisfied, Mr. Barnett?
Yes, Your Honor. Thank you.
Defense is
Ms. Wong?
satisfied as well. Thank you, Your
Thank
Honor.
you.
Sorry.
And, all right, now as to the explanation.
Your Honor, I did remind Mr. Jones that it is a court order not to use it, so he cannot without the court's permission. He does understand that. He does use it for primarily, he has issues falling asleep. He works 2 jobs with kind of a quick turnaround. So he finds it troubling, or he has difficulty falling asleep and remaining asleep in that short window and then getting to his second job. So that's why he uses it. That would be the medical need, and why he has been using it. I let him know he must discontinue. If he were to obtain a medical marijuana card and a letter of necessity regarding his sleep issues, is that something the court would consider? And I understand marijuana was a part of the underlying charge defense, but I wanted to ask if he got that documentation, if there's a chance he would be granted permission to use in the future.
No, it's a violation of the Medical Marijuana Act to be driving in such a way that you're now intoxicated to the point that you get a charge for it. So no, I'm not going to allow him to use medical marijuana when it's clear he's violated an act that he didn't even have the authority to be, when he didn't even have a necessity at that time. So no.
Understood. Understood.
So, Mr. Jones, just so you're clear, if you violate again, then what's going to happen is I'm going to revoke your bond. Do you understand?
I do.
So what's going to have to happen is he'll have a time period that he'll have to be weaned off of it. So I know he's going to test positive immediately and probably for the next 30 days, but any time after that. And if we were to test his numbers, they should be going down. Anytime after that, then he will be in violation. So you got about 30 days to get it out your system. Do you understand, sir?
Yeah, I do.
All right. As to the pretrial.
Your Honor, we are working towards a plea. We're just trying to get mitigating documents, and I know that was said at the last pretrial. There was a little confusion how we get those documents. Mr. Jones is working on signing the ROI, so we should have those. So if the court has availability for a brief pretrial, we should be ready, I would think, within the next 2 weeks.
No objection.
Thank you. Don't have 2 weeks, but I can give you September 11th.
Okay, thank you, Your Honor.
September 11th, 2024 at 9 a.m. Bond is continued. All right, thank you. We'll see you then, sir. State of Michigan versus Crystal Gelino, case number 23S00511.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Crystal Gelino.
Ms. Gelino, please state your name.
Crystal Lorraine Gelino.
Thank you.
You're welcome.
All right, Ms. White, you had a chance to talk to your client?
I have, Your Honor. As to the bond violations, she's going to admit to the bond violations. And as to the pretrial, I believe this is not a pretrial, but she understands that she will meet with probation, and we are asking as to bond that she be released to an inpatient facility as soon as a bed becomes available.
Thank you. Ms. Gelino, it's my understanding that you're going to plead guilty to the bond violation. I'm going to include the bond through the date of July 9th at least. She was not arraigned on this matter until August 12th, but I believe that she just stopped testing at some point. Ms. Gelino?
Yes, Your Honor.
It's my understanding you're going to be pleading guilty to the bond violation. Is that correct?
I am.
You're going to waive your right to have the hearing in this matter and plead guilty?
Yes, Your Honor.
All right.
Might I ask for a little bit more transparency? I was told in my bond matter that I would speak to probation, and then I would wait for a bed to open in an inpatient. And I'm
Ms.
wondering,
Gelino, we're gonna get to that in a moment, okay?
okay,
So, you pled guilty on this case on May 31st. And then it looks like, on June 12th, you missed a scheduled test time between 6 a.m. and 9 a.m. You didn't test until 9:16, is that correct?
yes,
Then on June 15th, just 3 days later, you tested at 8:40 a.m. as scheduled, but was positive for a BAC of 0.070. Is that correct?
yes,
You retested on 3 separate occasions, still testing positive. Lowest number is 0.066, correct?
yes,
Then you started to miss the retest at 9:50, 10:20, and 10:50. Is that correct?
yes,
On June 15th, June 16th, June 17th, you missed test those dates, correct?
yes,
And then you stopped testing, period, and hadn't tested since June 22nd for a total of 34 missed tests, correct?
I believe all that's true. Yes,
So you just absconded from supervision in its entirety, correct?
yes,
All right. I find that there is a factual basis for the bond violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Satisfied, Your Honor.
Thank you. Now, what were you saying, ma'am? You wanted to talk to me about being released to treatment?
yes. I was wondering if it could be a little bit more transparent where I'm to serve this out and I could make up my mind. I didn't realize that Dawn Farms was on the table, and if Dawn Farms is,
You're not serving a sentence. Well, you have pled guilty, but you haven't been interviewed yet, so you're not serving a sentence just yet. You can talk to the probation department about all of that, and maybe someone can work it out for you if you'd rather just sit there.
okay,
Okay?
thank you.
And then when you come back the next time, maybe it won't just be a misdemeanor, it'll be a felony, and then you can do some time in prison.
Well, if I stay away from the courts and maybe go to an Ann Arbor court when I have something, maybe they can help me.
Yeah, maybe so. That's your choice.
Okay. Miss McDuffie dictates everything, so.
Ms. McDuffie, since she keeps calling you out, do you want to respond to anything today?
She done told you that she was gonna lie in your court and you got the
Ms.
message.
Dellamino, Ms. Dellamino, let's stop now, please.
I would like to respond, Your Honor. Thank you for that.
You may.
I'll keep her tied up in court for years.
Ms. Dellamino,
Oh, I'm not on mute, excuse me.
You know you're not on mute, ma'am. Don't play games with me. Because you're going to find yourself in contempt next, okay?
Yes, ma'am.
Ms. McDuffie?
So the reason I keep referring to a sentencing memo in this case, I think is probably obvious by now. I don't think I have yet had a defendant show up to court with my name in their mouth about 6 or 7 times before I've said a word. In this case, my concerns that I've already articulated about Ms. Gelino is that despite her somewhat willingness to admit to the fact that she has a serious, extremely serious alcohol substance abuse problem, that she is also very manipulative and in denial on some level, which is that everybody else is the problem. And down to, I do want to make the record clear since she put all this on there about it. Ms. Gelino previously had an offer. She had a couple of different options for an offer. She wanted to dictate the terms for all of those options and more. What those offers did not include another stint at the 15 District Court's mental health treatment court. I cannot really these courts are confidential. I can't really get into detail about what I happen to know about Ms. Gelino's journey or experience in that court. But what I do know is that this court's recovery court is focused on substance abuse, and we are aware of mental health concerns, but there is a different approach and to the supervision and accountability that I know that this court takes with the substance abuse issues that we handle. And I think that that was necessary and would have been very helpful for her. Ms. Gelino has refused that level of accountability, and she wants to go have it the way that she had it in the mental health treatment court, where those issues, quite frankly, were not addressed, as we can see. Ms. Gelino has blamed everybody else, including the fact that she has to witness and be around other people's crack pipes in the city of Ypsilanti for her substance abuse problem, for her consumption of alcohol, for her being in this situation because of her behavior when she is under the influence, down to dictating where exactly she wants to go. I have never, as the court said, suggested once that if you fail at something, we don't try it again. It's exactly the opposite. We have people in our courts who have tried recovery programs, I think upwards of 30 times. And finally, they made the decision to be honest with themselves about getting the help that they needed, about to stop trying to run their program and to dictate their circumstances, because it clearly hasn't been working so far. I don't know what it's going to take for Ms. Gelino to get there, or to understand that I'm not her enemy, to understand how much her behavior is damaging herself and her family. But that's what I am here to see about, is that we do everything we can to ensure that happens. That solution is not one that she can create for herself, because she's not in the position to control her own recovery when she's the one that needs it. With that being said, Ms. Gelino can insist that she wants nothing to do with this court's recovery court. We can't make her do that, but she is on probation, or whatever the sentence that this court plans to impose will be. And so I am still committed to ensuring that we do everything we can to get her to the place where she can finally start to engage in her recovery and what she truly needs for it. Ms. Gelino was also in custody, or at least she was at one point, because she had a new offense committed while on bond for this case. I looked into that. I don't think that it's that case is, I think the warrant was authorized, but I don't know if it's an open case that's out pending yet again too. So I don't have any issue with Ms. Gelino being released to a treatment program. As you said, it needs to be the longest term I think that we can get. I would request confinement to that facility or that location. And I don't know to what extent an assessment is going to yield us some useful information in terms of where she needs to go and what she needs to do. I don't think that we're able to provide information to the assessors, because I don't think it works that way. So I'll turn over everything that I can to the court based on what I know that may be helpful for supplementing the decisions that the court needs to make with her moving forward. But Ms. Gelino knows good and well that I am not running this show. I am not dictating what happens in this courtroom, but I am here to tell the truth, and I'll continue to do it for her best interest.
Well, I don't believe that.
Ms. Gelino.
Oh, all right. We're here today for a bond violation. She's pled to the bond violation. We've accepted that. She's made her statements regarding how she feels about this court, about the prosecutor, about the recovery here, about Ypsilanti, and we are fully understanding that. And if she chooses to sit there, she can do that. I will modify the bond to have her released to a long-term inpatient program after she is interviewed by the probation department. And then if she doesn't want to go, she doesn't have to go. Obviously, that's up to her. And we'll see how things go in the future.
Thank you.
We'll see her back here on September the 23rd for sentencing at 10 o'clock p.m. a.m. At 10 o'clock a.m. Bond is continued otherwise. So she's remanded with the release.